What's up, everybody? So I'm back and we're continuing to go over the court's response to Kathleen Zellner. This is response to the motion she filed in January of 2023. They finally responded. I will link the other parts of this video in the description below so you can get caught up. But we're going to continue right where we left off. The defendant rests his motive arguments on the premise that Bobby Dassey had an obsession with violent sexual pornography involving young women and a fascination with gruesome homicides and deaths. However, the defendant's arguments are not supported by the evidence submitted, as the Court of Appeals has already concluded the defendant did not establish that it was Bobby Dassey who concluded the searches in question. The Court of Appeals ruled that even if the defendant is correct as to what the usual schedules of the Dassey family members were, those general schedules are not proof establishing where any specific member of the family was on any given day. While the defendant argues that nothing short of recording of Bobby Dassey conducting the searches on the computer would satisfy the standard of proof deemed by the state, this assertion is not true. The defendant could have offered any piece of evidence that during the time in question, Mr. Dassey entered some type of identifier unique to him, such as a specific username or password, to establish that he was in fact the person using the computer to conduct the searches cited. The defendant could have offered a witness who saw Mr. Dassey actually conducting any of the searches in question. Even more simply, the defendant could have offered the evidence that the defendant was actually home at the time of the searches rather than speculation based on the typical schedules of the family to prove that Mr. Dassey conducted the searches. The Court of Appeals has already concluded that the mere fact that Mr. Dassey may have been home during the time that the searches were conducted, there was not conclusive proof that he was the person who actually conducted the searches, and that the defendant relies upon to prove motive for the murder. The defendant's reliance on Dressler is also misplaced. The facts in Dressler was substantially different from those in the current case. The defendant in Dressler was shown to have very specific images in his possession that closely mirrored the evidence found at the crime scene. The instruments involved in the murder were found in the defendant's exclusive possession. The totality of the evidence proved that the defendant was in possession of incriminating evidence prior to the commission of the crime. In this case, the images and terms searched by someone in the Dassey house on the family computer do not closely mirror either the method of murder or disposal of the remains in the case. The searches offered by the defendant refer to generalized violent pornography and term searches. No search results offered by the defendant directly mirror the elements of the crime in this case. There is no evidence, only general assumptions that Bobby Dassey was the individual who conducted the searches on the family computer. The computer was not in the exclusive possession of Bobby Dassey prior to or after the murder. There's pictures of it in his bedroom. No, the computer. Only a very small number of searches were conducted prior to the murder of Teresa Halbach. No physical evidence directly linking Brian Dassey to the homicide was found in the house. The defendant offers argument that Bobby Dassey had pre-positioned to commit the crime based on an addiction to violent pornography. The defense offers two experts who discuss the role of pornography in the commission of the crime. Putting aside any question as to the qualifications of the experts to opine on this matter, both of the conclusions researched by experts depend on the assumption that Bobby Dassey was the individual researching the pornography on the computers, a fact not established in this matter. Furthermore, the experts researched their conclusions without doing any forensic or physical examination of Bobby Dassey in person. Their conclusions as to his mental state are based on evidence that are not admissible in this matter. The defendant has not met the burden under Denny to establish that Bobby Dassey had motive to commit the crime alleged and as such failed to meet the burden to admit the evidence offered to prove the existence of a third-party suspect for the commission of this crime. Without such a finding, the defendant cannot meet the third element of the Edmonds test that establishes the evidence in this material in his case. As previously noted, evidence that simply affords a possible ground of suspicion against a third party is not admissible. Even if the defendant had met the burden with respect to the motive element of the Denny test, he has not met the burden with respect to the element of opportunity under the same test. The defendant asserts that the legal term of opportunity is broad and encompass other acts, evidence that may otherwise be inadmissible. The defendant states that the opportunity can include the individual's physical presence at the crime scene or proof that an individual has the skill, capacity, or ability to carry out an act. The defendant also notes that it is incumbent on the proponent of the evidence to show the relevance of the evidence offered. The defendant notes that Mr. Dassey was present on the Avery family property on the day that Teresa Halbach's murder took place. The defendant then refers to the affidavit of Mr. Sawinski to further support his other arguments. The defendant argues that the affidavit of Mr. Sawinski establishes that Bobby had possession of the RAV4, therefore he had access to the evidence that the defendant asserts was planted to frame him. Specifically, the defendant asserts that Bobby's possession of the RAV4 gave him access to the key found in the defendant's home and the victim's personal electronics found in the burn barrel. The defendant further states that Mr. Dassey had access to his blood because on November 3rd, 2005, the defendant reopened a cut on his finger and dripped a substantial amount of blood in his bathroom sink and on the bathroom floor. The defendant then states that he went to Dassey's residence to ask Bobby and his brothers if they would like to go to the store with him and his brother. According to the defendant, Bobby decided to stay behind. It was also at that time the defendant states that Bobby saw the open cut on his hand. The defendant states that when he left for the store, he left his trailer unlocked, and upon leaving, he saw taillights of a vehicle near his trailer. The state agrees that in some instances, an individual can be implicated in a crime by the mere proximity to the crime scene. However, in the matter before the court, the state argues that the defendant is offering much more than a complicated scenario as to Bobby Dassey's opportunity to commit the crime. Referring to the defendant's argument, in order to satisfy the Denny test, the state asserts that the defendant must offer evidence that Mr. Dassey had the skills, contacts, tools, time, and or other means to have committed the crime and staged the scene in the manner alleged. The defendant must provide evidence that the third party had a realistic ability to engineer such a scenario. The state argues that the defendant failed to meet the burden in this matter. The state asserts that the defendant has offered no evidence to establish that Bobby had the opportunity to successfully orchestrate this extremely complicated scheme to frame his uncle. The state argues that the complete absence of any necessary facts to support the defendant's argument demonstrates that the defendant has insufficient evidence to show that Bobby Dassey had the opportunity to kill Teresa Halbach and frame the defendant in the matter the defense claims. The state goes on to argue that the defendant has offered no such evidence to establish that Bobby had the necessary skills available to manipulate the evidence in the manner that would implicate the defense. The state also notes that at the time of the murder, Bobby Dassey was an 18-year-old high school graduate with no criminal record. Mr. Dassey was employed as a third shift worker at a furniture factory. The state states there is no evidence of record that established how an individual of Bobby's age and experience would have obtained the scientific knowledge or skill to collect, transport, and plant the defendant's blood from his bathroom. The state notes that nothing in the record indicates how Mr. Dassey would have obtained the necessary materials to collect and transfer evidence in a manner successfully, as well as in a manner not detected after analysis by the crime lab. The state points out that the defendant in his brief in chief does not address how Bobby transferred touch DNA to the victim's car. Furthermore, the state notes that the defendant does not explain how Bobby could have kidnapped and killed Teresa Halbach, then hid her body within minutes of being seen on the highway at approximately 3 p.m., referring to the record that the state asserts that it contains no explanation or evidence to establish how an individual with Bobby's age, education, and experience discovered a tiny mangled bullet fragment that he knew had the victim's DNA on it and planted it in the garage, or alternatively shot the victim there on the 31st and managed to thoroughly clean up the scene without the defendant noticing Bobby, even though he was using the garage to work on vehicles during and after that time. The state additionally argues that there is nothing in the record explaining or supporting the theory that Bobby moved the victim's body and burned it at some undisclosed location and moved the bone fragments from almost every bone in the human body back to the burn pit on the Avery property undetected, while the defendant asserts that Bobby planted the key to the victim's RAV4 in his trailer between November 3rd and November 5th. The state notes that there is no explanation as to how Bobby could have moved the car from the property without the keys, driven away from the property, walked back to the property, and replaced the keys in the defendant's trailer without anyone noticing. The Wilson test requires that the defendant must provide evidence that Bobby Dassey had the realistic ability to carry out the complicated plan that it alleges was used to frame the defendant. The defendant speculates on many points as to how Bobby could have carried out the plan to frame his uncle, but the Wilson test requires more to the defendant. The defendant has failed to offer any evidence that Bobby had the scientific knowledge to recognize the significance of each piece of the forensic evidence supposedly planted by him, let alone establish that he had the skill to plant that evidence in a way that would stand up to scientific scrutiny by professional crime scene analysts. The defendant supports no evidence supporting his claim that Bobby had the knowledge to create and execute an elaborate plan to commit a murder and frame his uncle. That's where I'm going to end this part. I will link all of the other parts in the description below so you can go have a view for yourself if you want to get caught up. Let me know what you think. Leave some comments below. I hope you're having a good day, and I will see you again soon.